Okay, Erin, we are good to go.
Good deal. Okay, so Gretchen, you would like to do a roll call?
I would be happy to, everybody. So I'm going to help with introductions really quick. Let's see. Maybe I'll say your first name, and if you want to sign in and say hi and do a quick introduction, that would be great. And why don't we start with Elizabeth?
Hi, my name's Elizabeth Infante.
Thank you. Oh, go ahead. I'm sorry, I interrupted you.
I forgot we don't have to go in any further, right?
That's up to you all. If you'd like to add a little bit.
I'm Elizabeth Infante. I'm happy to be here.
Welcome. Very good. Let's see. How about Oni?
Good afternoon, everyone. My name is Oni Marchbanks.
Thank you. How about Tracy?
Hi, everyone. My name is Tracy Powell. Happy to be here.
Thank you. Welcome. And how about David?
Hi, my name is David Reinhold.
Thank you. And Grant?
My name is Grant Yoder, and I'm nearly as happy to be here as Elizabeth.
That's awesome. And let's see. Sergeant Galvin.
Hello, my name is Steve Galvin with the Salem Police Department.
Thank you. And Mark.
Thank you, Gretchen. My name is Mark Weinstein. I'm an assistant city attorney with the city of Salem. Some of you are new to the board. I think this would be my second meeting with you. I've been working with the CPRB for 5 years now, and we've had some readjustments of assignments within the city attorney's office. So this is actually going to be my last meeting as the legal advisor to the CPRB. Ms. Lori Evans will be taking over for me. It's been a genuine pleasure working with the board through the years. I don't believe anybody that's currently on the board was on the board when I first started. I can't remember, David, when you started with the board, but the other faces have joined the board along the way. But I've genuinely enjoyed working with this board and being your legal advisor for the past 5 years. And thank you for having me.
Sorry, did you say Lori Evans would be joining?
Yes.
Nice. I used to work with her when I was at Marion County.
Oh, great.
I hope to see her again.
Thank you, Mark.
Thank you, Mark.
Yeah, Mark, it's been just a pleasure. And that's a perfect time for me to introduce Lori, who's with us tonight.
Hello, can you see me?
Yes.
Oh, okay. Hi, I'm Lori Evans, and I'm also happy to be here. But thank you for the introduction, Mark, and I look forward to working with you all.
Very good. Thank you so much. We appreciate it. And then let's see, Les is here.
Yes,
Les?
Gretchen, thank you for the opportunity to introduce myself. And Mark, I apologize for, yes, I apologize, Mark, for misspelling your name in my email. I don't know how I ended up doing that, but I'm going to miss Mark. He's top gun, and I look forward to meeting and learning about Lori. But again, thank you for accommodating my interest simply as an interested person.
Of course. Thank you for your interest. And Lieutenant Ditto.
Hey, good evening. Brandon Ditto. I'm a lieutenant here with the Salem Police Department.
Excellent. Thank you. And my name is Gretchen Bennett. I'm on the staff team at the City of Salem's Mayor and City Manager's office. And then Erin, I think you are my last one. Introduce yourself.
I'm Erin, and I'm the chair of the board. And I think that's it, Gretchen?
Yes. Yes.
Okay.
I think we've got everyone introduced now.
Awesome. Okay, now we're going to go on to approving the minutes. Did everyone get a chance to read those? Anyone want to approve them? No takers? Okay.
So you'd invite, if anyone would be up for making a motion to approve the minutes, and then
Yes.
we'd need a person to make a second and then we'd have a vote is how that
Any-
part would go.
So
Oh,
this
yeah,
is, then I'll make a motion to approve the minutes.
I second that. I read over these and they're correct.
Awesome. And anyone think there's changes to be made? No? Okay. Anybody have public comments?
I do want to just point for the record, we had an email comment from Les Ruark, who's also with us this evening. And I forwarded Les's email to you at the time when I attached Mark's presentation. So just wanted to make you aware of that. But I'm not aware of any other public comment this evening.
All right. The request for reviewing hearings, and I see that there's none received. Is
Correct.
that correct?
Yeah.
Okay.
Yeah, yeah.
And then, so we're just zipping along. Trainings, public meetings, and ethic. And that's a really big word. I don't know it. Sorry.
I'm going to be talking, Chair Hull, if it's okay. I'm going to be talking about public meetings law and ethical considerations for public officials. Before I launch into my presentation, a few things. I don't mind being interrupted at all. So if at any point in my presentation you have a question about a point that I'm working on, and excuse the barking dog in the very background. One of the joys of virtual meetings. Please, probably the easiest thing to do is there's like a raised hand thing where it puts up a little yellow raised hand thing, and then you can fumble how to put it down later, which I think eventually it disappears, but do that. And I'm experimenting with moving away from a headset and a microphone to using a microphone that's on my camera and then speakers. I believe I've got it down, but if at any point feedback starts coming through as you all are communicating with me, let me know and I'll try and make some adjustments, all right? So with that, let's do this. Are you all able to see my presentation? Great. So like I said, my name is Mark Weinstein. I'm an assistant city attorney with the city attorney's office. I've been with the office for about 7 years. Started with a prosecutor in the office and moved over to the general counsel side of things about 5 years ago. And during that time have been the legal advisor to a few different boards of commissions, including the CPRB. And today we're going to be talking about some things applicable to the boards and commissions in the public meetings law, as well as some ethical considerations for public officials. And with that, let's get started with public meetings. So the public meetings law is codified in statute. It's in ORS 192 if you ever want to take a look at it. But the policy when it was adopted is that it was going to be the intent of the Oregon Public Meetings Law that decisions of governing bodies be arrived at openly, that it was a desire that Oregon have a form of government where the public was going to be informed of the decisions that its policymakers were making and the reasons that they were making it. So it was to promote an open form of governance. And so the laws then were designed to ensure that these meetings of the public bodies at which decisions about public business were going to be made or discussed. So even if it was just a discussion about the public business that was going to lead to a decision, that these were going to be done in the open to the public, that the public was going to have notice of the time and place of meetings. No point in having a public meeting saying, hey, we're going to let the public know what we're doing if you don't tell them when that meeting is going to happen and where it's going to happen. And that meeting had to be accessible to all, which is why, for example, when COVID hit and everything moved to a virtual forum, we were still required to notify people of when these meetings were happening, in what format they were happening, give people who are interested the link to the meetings. So even though we were switching formats, it still had to be accessible to the public. And we do that whether it's in person or virtual. And so the beginning question is, who's subject to the law? And public meeting law applies to all meetings of a governing body of a public body. So it's a public body. The public meetings law doesn't apply to private corporations that are doing just their own business, not in relationship with a government entity. So it relates to a governing body of a public body for which a quorum is required in order to make a decision or to deliberate toward any decision on any matter. So it's not a department head making a decision regarding, what time they're going to have their staff meeting, or a decision on a question that a particular employee has about a particular project they're working on. But these are deliberations and conversations by a governing body in which a quorum is required to make a decision on the matter. So what's a governing body? A governing body is any two or more members of a public body that have the authority to make decisions for or recommendations to a public body on policy or administration, such as CPRB. The governing body of the city will include the city council, all boards and commissions, and any other body within the city that has authority to make decisions or make recommendations on policy when there's a quorum that comes together to make those recommendations or decisions. And a public body is a city or county or any other subdivision of the state, as well as the state itself. So the city of Salem would be a public body, the city council, the CPRB, those are a governing body within the city of Salem. So what meetings of the city are subject to the law? Well, the meeting is when the governing body comes together, and which a quorum is required in order to make a decision or to deliberate toward a decision on any matter. So let me give you a very easy example. Let's say we're going to have a change in an ordinance for the city, or the city is going to enter into an agreement with another agency that requires vote by the council. So in that situation, the council would need to have a quorum to make the decision whether or not to make a change or enact an ordinance. That would be a public meeting, because it would require a quorum of the governing body to come together to make that decision. No person can just within the city unilaterally decide to enact an ordinance. Public meeting law is going to apply to a meeting even if the sole purpose of the meeting is to gather information, which will then later be used to make a subsequent decision or recommendation, not that the decision will be made at that time. A perfect example of this is work sessions. It is common for the city of Salem council to have a work session on a particular matter where they need to discuss and gather information on a topic, but that discussion is going to be so lengthy, it's not appropriate to have at a general city council meeting. So they'll hold a work session. But even though they're not going to make a decision, if they're gathering information that's going to subsequently be used toward making a decision, then that has to be done in a public meeting format. What's not a public meeting, purely social gatherings, where official work is not discussed. Trainings, if it's not trainings that are designed to then educate for the purpose of deliberation, but it's just a pure, welcome to the city. Here's how the city is structured. Here's who reports to whom. It's just more sort of an orientation, so to say, as opposed to a substantive training that the information is being provided to then help the board in its deliberations. Site visits of less than a quorum, where it's purely, looking at the library, gaining in a non-quorum situation, things along those lines, where it's not information that's being given or there's not a discussion that for a future action. So I'm just going to go a little bit far afield. It's not common that this board goes into executive sessions. In fact, the only time it would go into executive sessions is in the course of an actual case review. There are certain times under the law where and it's delineated specifically within the public meetings law, but in an executive session, the public is not invited. It's just the governing body, but it's for certain things. For instance, a labor negotiation would be an example, or a real estate transaction would be another example where there can be an executive session. Just a few key points on that. You can't make an actual decision in executive session. You can only deliberate and discuss. The public still has to have notice that there's going to be an executive session, and a news media can attend most executive sessions, but they're limited on what they can relate regarding the executive session. So one of the most important things that's being discussed recently under public meetings law is the notion of serial meetings. It stems from some things that happened in a couple cases out of Lane County, Dundee and Handy. And this is why when you receive a communication from staff, you don't see who else is getting that communication. You're BCC'd as opposed to CC'd. So when you respond, you can only respond to the individual staff member who is sending you the communication to avoid people running afoul of the serial meeting rule. And so let me discuss that with you. So a serial meeting is when a quorum of a governing body collectively deliberates or decides on an issue in a series of meetings, even though there's never a quorum at any one given time in any one meeting. So, for example, two board members meet and they decide how they're going to vote. And then one of them meets with two other members and they agree how to vote. And it goes until the point where enough board members have communicated on their vote that they've hit a quorum number. Okay, well, that seems like you can pretty much figure out when people are meeting in person, but meetings aren't just in person, it turns out. You pick up the phone and you talk to another person on the board about something and you start deliberating and gathering information and communicating information that about a decision you have to make, or you discuss how you're going to vote specifically by telephone or more commonly by email. So two of you talk about, hey, we've got this case review. There was that evidence presented. I think we should vote this way. And that string gets forwarded to another member of the board, and it gets forwarded to another member of the board. And eventually there's enough people seeing and discussing how you're going to vote, even though you've never been in a room together, never talked to each other verbally, but you've done it all by email. That becomes a serial meeting. And this all stems from a discussion that happened of a couple matters that happened down in Lane County on their Board of Commissioners, where during the course of scheduling a meeting, of the Board of Commissioners, comments started happening within the email string about the substance of what they were going to be meeting on and how individual members of the Lane County Board of Commissioners felt about it. And even though it was a string discussion, there was enough discussion within that email that the court eventually said, you violated the public meetings law because you were deliberating in a private setting, in email exchange. The public wasn't allowed to be there. And you guys, enough of your board discussed it and gave your input on how you felt about this matter and deliberated on it, that you hit a quorum, you ran afoul of the public meetings law. And so some lessons from that is that, very importantly, the use of an email by a quorum of the governing body could constitute a meeting. And again, that is why when you get a communication from staff, we take the very conservative approach, no matter what we're doing, that we send it to you where everyone is BCC'd. So if you accidentally hit reply all, as opposed to reply, it's only going to staff and not the other board members. It's also why we ask board members to not be communicating with each other, but to have that communication through staff to make sure that we don't run afoul of this serial meeting and public meetings law. And so serial meetings will violate the public meetings law if at least a quorum of the governing body made a decision or deliberated on a matter in a setting that was private and not open to the public. And obviously telephones and emails or discussions in Starbucks are going to be like that. And knowledge of the law and failure to comply with the requirements of the law may also constitute a willful misconduct that will subject you to personal liability. So the Lane County Boards of Commissioners, the courts found that their actions were so egregious that they should have known the law, and what they were doing was so egregious that in addition to fining the public entity, they also held the members of the board that participated in this individually liable. So again, all the more reason why we try and prevent email and phone communications directly through board members regarding anything that could be conceived or perceived as board business. A couple other things on public meetings. Remember that use of your personal computer and private email account to conduct public business may subject your personal computer or your private email account to disclosures under a public records request. So it's always our advice or recommendation that obviously most people are not going to get a personal computer that they only use for CPR business. It becomes a little bit more of a reasonable request if you're like on the city council or something like that, where your work for the city is a little bit more extensive. But we do always suggest to people that they have perhaps a separate email account, since email accounts are free, that they use exclusively that email address for when they're doing CPRB business or receiving communications from staff at the city. Regarding this, it makes it very easy to, if we receive a public records request that requires us to harvest any emails on a particular subject, both within the city or that was communicated to and from the CPRB, that we can easily find that. In the 5+ years that I've been doing this, I've never had a situation come up where we've had to do that. But now that I've said that, I've tempted the devil to make that public records request. So it's something you may want to consider. And if you do generate an email that's solely for the CPRB use, please make sure that Gretchen has it so that she knows to communicate with you through that. And just again, just consider this is just something I give to all of the public officials. I advise that the more that you're going to be engaging in working on public business, the more you should consider using either a device that's dedicated for that or some type of an account, like an email account that's solely dedicated for doing your public business on. Before I move on to ethics, does anybody have questions regarding public meetings law and how it relates to the CPRB? Okay. So then let's go on to ethics for public officials. The policy behind the ethics laws, both on the state and local level, is that public office is a public trust. It requires compliance with ethic rules. Something that's important to note is that the city has different and more restrictive ethical standards than state law for its elected officials, its appointed officials, and employees. So we're going to talk both about the state law ethics and how it applies to the boards and commissions, as well as the city's independent ethics laws. So the state law establishes ethical rules regulating the following: conflicts of interest, gifts, and use of public office for private purpose. So the question becomes, well, who is a public official in relationship to our ethics law? If it's a person who serves any public body, the city council, members of the boards and commissions, staff, consultants, volunteers, anybody who's serving the public body in relationship to the ethics law would be subject to the ethics law. And it is regardless of whether or not you're compensated for it or not. So because you all have taken volunteered to give up your time and to do so for free, and to have positions of responsibility in relation to the city, you have also made yourself subject to the state and city's ethics law, even though we're not going to compensate you other than the reward of being on this board and commission. So let's start with conflicts of interest. So there's two types of conflicts of interest governed by the ethics law. There's an actual conflict of interest, and that's when an action, decision, or recommendation is made by a public official, which all of you are when you're serving on the CPRB, that would actually result in a financial benefit or detriment to you, your relatives, any business that you're associated with. The city code is more expansive. Here, an actual conflict of interest under the city code is any benefit or consequence, not just financial. A potential conflict of interest is the same, except that that decision, action, or recommendation could result in a financial benefit or detriment. And under the city code, it's more expansive. It's not just financial, it's any benefit or consequence, not just financial, to not just you, but also your relatives, business, or officials you're associated with. Perfect example, it's an extreme example, but it just jumps out at you. If we get a request for a case review and it's a relative or somebody who's associated with you in a business, obviously you would want to declare that as a conflict of interest. Because under our code, that recommendation that you made could have a benefit or detriment to that person, and it would likely be covered under our ethics code as a actual conflict of interest. So what do you do if you determine that there is a conflict of interest? If it's an actual conflict of interest, you have to state publicly the nature of the conflict and refrain from discussing or voting on the matter. For a potential conflict, you must state publicly the nature of the conflict before taking action, but you may participate in the discussion and vote on that matter. This is under the state code. Under our code, we have what's called an appearance of impropriety rule. And I'm going to talk to you about that in just a second. So that our ethics code is found in Salem Revised Code, Chapter 12. It's based on the state law, but it's more restrictive. And we've talked about areas where it's more restrictive. It's not just a financial benefit, but it's any benefit. And there's the conflict of interest is more expansive. We add in the appearance of impropriety rule. Special favors run afoul of the ethics under the city's code, and there's some non-disclosure requirements. So let's talk about that appearance of impropriety rule, and it's found at SRC 12.020. And just so you know, and I hope you've all had a chance to explore our website. We just launched a new website within the last few weeks, but our code has been and remains on our city's website under laws and rules. And if you look this up, a public official's conduct in both their official and private affairs should be above reproach. This is what I call the gut check rule. If you're ever in a situation, and I have this exact conversation with Gretchen at times where we'll get something and I'll say, well, let's talk about the gut check rule. If you get to the point where something is happening in relationship to your work on the CPRB and you say, I'm not sure if I should be involved in this matter. If you're concerned about it, my advice to you would be go take a look at SRC 12.020 and the appearance of impropriety. And we need to be above reproach. Give yourself a gut check. If you continue to engage in the deliberation or the recommendation or whatever, do you feel you're acting above reproach? Or if you have, or is your concern telling you that maybe you shouldn't be involved? And so if you have you need to avoid the appearance of impropriety. And so even if it's a potential conflict of interest, if you're going to have an appearance of impropriety by you being a part of the decision maker, you would be running afoul of that appearance of impropriety rule. Okay. Some other things within the Salem Revised Code is the fair and impartial fulfillment of duties. You can't contact counselors to attain preferential consideration in connection with employment. That would result in disqualification. You can't use city-owned property for private use. No public official shall grant any special privilege to any citizen what is beyond every other citizen. I don't see that becoming something that would come up within the CPRB, but these are some examples of some other ethical duties that are put in our code that aren't within the state code. And confidential information can't be disclosed. So if you are in a case review and it moves into executive session and confidential information is disclosed to the CPRB in executive session, you cannot disclose. It is a violation of our code and your ethical responsibilities to disclose confidential information that is provided to you in that executive session or in any forum, and to use that information or disclose it in any way, shape, or form. So what are the consequences if you violate the state or city law? Under state law, you can be looking at a civil penalty. And I say you, I mean you. you individually could be looking at a civil penalty. You could be looking at forfeiture if you've gained anything from that violation. And there's the status of having been sanctioned. In addition, under the city code, you could be looking at removal from office or other disciplinary action. And our charter, I believe it's our charter, gives the reviewing authority the authority to act accordingly in its discipline or sanctioning of the person who violated the code. So in addition to our code, our charter as well has additional requirements. And this is, our charter is also on our website. If you go under that same area of laws and rules, our charter is there as well. Chapter 62 applies to elected and appointed officials at public hearings. It requires the disclosure of certain gifts, relationships, and campaign contributions. And it requires recusal if the gift, relationship, or contribution creates an appearance or bias of impropriety, similar to what we see in our code. So again, if you have some type of relationship or you receive some type of a gift, and that relationship can be personal relationship or professional relationship, or there's some other type of situation that creates an appearance of impropriety in the mind of a reasonable person, you need to recuse yourself from being a part of that deliberation or recommendation. Similar to what's in our code, it's also in our charter. There are some complicated exemption procedures. I would sooner believe that and the rarest of things would occur before it would ever be that the CPRB would be in a position where you would be exerting a exemption from this. So I'm not going to go down this road too far. So here are the important takeaways from the ethics portion of this presentation. It's your personal responsibility to comply with the ethics law. So if you violate the ethics law, you are personally liable for violating the ethics laws. You have to comply with both the state and city ethics law, and the more restrictive provision always controls. So even if it's not a financial benefit or consequence, but some other type of benefit or consequence, which is what the city code says, that applies. And you have to comply with it. Even though you could, let's say it's a potential conflict where you could declare it and you could then deliberate, but that would be allowed under the state code, but doing so would create an appearance of impropriety. You'd be violating our charter and our code. And so that appearance of impropriety rule would govern that situation. So what's the role of the city attorney's office in relationship to this? Our client is the city or the board. In relationship to the ethics law, we do not represent public officials in their personal or professional capacity. Public officials cannot rely on the advice of legal counsel as a defense to violations. I put this in my presentation. So if something happens and you can't pull out this PowerPoint and say, look, Mark Weinstein told me this. Mark Weinstein told you actually that you shouldn't rely on Mark Weinstein in relationship to your ethical obligations. We can give you some guidance on what you might want to look at, but ultimately it's your own personal responsibility to educate yourself on the ethical obligations of your position and ultimately to make that decision on what you are required to do. There are some resources that are extremely helpful if you find yourself in a unique ethical quandary. The Oregon Government Ethics Commission, their website has a lot of guides and informations on the typical things, like how much of what gifts can you accept? What are the limits on that? And in what situations, etc. You can also reach out to the Oregon Government Ethics Commission. Most of their advice is not going to exempt you from liability unless you get an official commission opinion. And again, in my 5+ years of working with the board, any of the boards, I've not heard of anyone obtaining an official commission opinion. Another way you can go is our city hearings officer is able to receive and initiate ethics complaints. The hearings officer can investigate ethics complaints and also can render advisory opinions or interpretations. So if you're at a point where you're having an issue, you might want to get an advisory opinion or whatever, you could certainly reach out to the city attorney and see if that's something the city would champion or not. Especially, we would probably point you first to the Oregon Government Ethics Commission to see what advice they would be able to give you as well. That's what I got on these topics. I appreciate your time. I will stop the share so you all are larger icons again. Does anybody have any questions about either of those topics? All right, well, I appreciate your time. Hopefully you gained some information out of my presentation. Again, it's been a pleasure working with you all for the past 5 years. I've been working with Lori now for several years. I've known her even before that through the Oregon District Attorneys Association there. You are in incredibly capable hands, and I think you're going to really enjoy working with her. Les, I see you have your hand raised. I can't hear you. There we go.
I do, Mark. And would the chair allow an interested person to ask a question here at this point? Can you hear me?
I can hear you, yes.
Okay, I'll go ahead. I just want to make sure it is appropriate for me to be able to ask a question at this point. Is the chair comfortable with that?
Yes.
Okay, fine. Mark, here's the question that in response to what you were talking about, and I appreciate all that you said. It was a good summation. What's the definition or the normal or usual record, if there is one, considered to be confidential information as a part of the review hearing process? What I'm asking there is there anything that an average person would be able to look at generically in terms of a form or what the actual review process entails?
I can't give you a specific answer to that, Les. I think it would depend on what information. There are some forms that are filled out requesting the review and things like that. Depending on what information the appellant put on the form itself, there may be some confidential information contained within that. There are certain things, if there was personnel records that were being offered into evidence during the course of a hearing, those would be confidential along those lines. I would look to guidance from our public records law as to confidential information. I'm not saying that that would be the only thing that would guide that decision. It would depend on what the information that was submitted and not necessarily the forum or form in which it was submitted that would govern whether or not it would be confidential.
And thank you, appreciate it.
All right. Seeing no other questions, thank you again. It's been a pleasure.
Thank you, Mark. Do we have board member comments now? Anyone have any comments? No comments. All right, I guess that concludes our meeting. Right, Gretchen?
Yes, you are at the end of the agenda. We will be at work to prepare oh, wait a second. Actually, I am forgiven. Salem Police Department, did you have anything that you wanted to share? I think that there might have been some updates from your end, but forgive me if I'm mistaken.
Yeah, I can speak to a few of those things. One, we don't have a whole lot, but I think the board members received an email. We are opening up the ride-alongs again for citizens and board members. If I was going to post in the chat the link to the website, but I can't figure out where the chat is, and I don't know if it's my computer or what, but it's just on the city's website. You can fill it out, the form, and then print it and bring it down to the city, or you can just print it and then handwrite it out. We just ask that you put at the top of it CPRB if you're a board member. And then we have a list of the members and we can kind of track it that way because there is those requirements. The other thing that we kind of mentioned in the email was about the tours. My email is in there. You can reach out to me, my city email. If you would like a tour of the department, we can coordinate what would work best for you with your schedule and my schedule, and we can get those taken care of.
Thank you. Sorry about that. I remembered that at the last minute. Thank you.
Not a problem.
All right, well, that concludes our meeting. Thanks for coming.
Thank you.